Good afternoon, everyone.
Hello.
My name is Tanya Walker, and I would like to thank you all for joining us today. If you aren't muted, could you please mute yourselves just to control the background noise? So I just wanted to, first and foremost, our friends for joining us today and promoting this webinar. I decided in the middle of last week to create this. Sorry, if anyone's on, mute yourself, please. Okay, so I'd like to thank everyone for joining today. And thank you to our friends for helping to promote this. I decided in the middle of last week that it would be beneficial for business owners to understand what's going on legally with all the changes with COVID-19, because there's new laws coming out like every day. And as a business owner myself, I thought, you know, this might be helpful. So I thank you to We Connect International. We Connect certifies majority-owned women businesses. Camp C does the same for my majority-owned minority and Aboriginal businesses. BB Grow trains women-owned businesses on how to get better. The Black Female Lawyers Network, I think the name speaks for itself, so thank you. Kim Niles, who's a fitness coach. I also would like to thank you. Peter Neal from Neal Brothers. Thank you, and your delicious snacks come in handy nowadays. So I'm going to start a poll, and I'll pull it up here. And I'd like you to just think about what really concerns you most about COVID and your business. And I'll give you a minute to answer. But I mean, the possible answers are the legal implications with your employees, your tenants paying rent, or that you may have difficulty paying rent, when or whether the court will be able to provide a recourse, and other. So I'll just give you a few seconds to respond. I'll just give one more minute for you to respond. Okay, so I'll end it here. And I'll share the results. So it looks like it's about even with both of you, with the team or the audience, that you're concerned about legal implications with employees, and that tenants or difficulty with tenants paying rent, or that they may have difficulty paying rent. I can understand that. It's a great concern that many of us business owners have. And I'm curious about the other. Hopefully I'll be able to find out that information from you. So before I go through the agenda, some housekeeping topics is that the link for this presentation will be made available afterwards, as well as a slide. A survey will also be sent out after this presentation. Those who complete the survey and complete the entire survey and subscribe to our e-newsletter will receive a Walker Law $5 gift card to Starbucks. Starbucks is kind of closed, but you are able to still order if there's a drive-through with Starbucks. And questions may be asked during the presentation. I'll try to answer as many as possible, along with my colleague Jordan. But we might have to end. This without answering all questions if there are too many. And I will just pause for a moment because I just realized that my email hasn't been closed, so I apologize for that. And I don't want everyone to hear that chime. There, I'm back to sharing with you. Okay. So just before we begin, our presentation is for general informational purposes only and not intended to be independent legal advice. That's our disclaimer. So before starting the presentation, I wanted to just introduce our legal team. So we have Marley Annette, who's a paralegal student. She also has a commerce degree. Jordan Koenig, who is associate employment law. And we've had an overwhelming response with employment law questions. And so Jordan is going to answer those questions today for you. Rishi Nagashar, who's our articling student, and he will also join us as a lawyer when he's called to the bar in June. Jordan Routliff, who is an associate with us, he articled with us, and he also specializes in property law. So just a little bit of information about myself. I started this law firm 10 years ago after practicing at two Bay Street firms. I've been a lawyer for 14 years. I appear regularly on 4 television stations as a legal analyst. And I also work with the Law Society. I'm the first Black female elected bencher, which is a board of director from Toronto with the Law Society in a 223-year history. So now getting into a little bit of the historical world changes. The focus of this webinar really is to provide suggestions to you on how to adapt to changes in the law today so that you can adapt as business owners or individuals and that you can avoid certain issues in the future. So this chart shows that throughout time, there have been events that have caused recessions or just concerns. So we've had 9/11, we had SARS, we had the subprime mortgage crisis, and now we have COVID-19. So recessions usually only last about 6 months, but my goal is to answer your questions, but also provide precedents or recommendations on how to deal with those issues so they don't really arise in the future. So speaking about the law, I really noticed that there's a trend in Ontario towards limiting movement, limiting our autonomy. And so we have a number of countries that have more limitations on movement and lockdowns or quarantines, and you can see the 6 here. Now, before I continue, COVID-19, it really stands for coronavirus disease of 2019. It usually causes a respiratory failure. It really affects people with weaker immune systems and who are more vulnerable. I think it really impacts all of us. I know I'm personally impacted because I have an aunt and uncle in New York City who now have COVID-19. They're elderly, so I hope they recover. But it's really impacting everywhere across the world, all at the same time. The thing about COVID-19 is that a carrier may not even show symptoms and infect someone else. So the effect has been drastic of COVID-19. We all hear on the news about the number of deaths and a number of countries that are on lockdown quarantine. And why I say I believe Ontario's moving towards that is because has been laws implemented in the last week or so that says we cannot stand too close to somebody when we're in a public area. We have to have less than 5 people in a social setting. We're moving towards that direction. I wouldn't be surprised if we see more laws implemented that deal with that type of remedy. And so COVID-19 really seems to be impacting property law. RBC has provided an estimate that housing prices will decline by 30%. At least 1 million Canadians in the last month or so have filed for unemployment. And according to the Canadian Federation for Independent Businesses, the average business owner will lose $160,000 in revenue this year. So I'm not going to go through every single law that has come up because of COVID-19, just the highlights, really. And so the federal government has created the COVID Emergency Response Act that speaks of financial and tax incentives. There's an amendment to the labor code that COVID leave for up to 16 weeks. And then our provincial government, Doug Ford is actually going to make an announcement today at 1 o'clock. And there's speculation that he's going to make an announcement concerning masks, because there's an issue where I believe the President of the United States of America is kind of directing 3M not to provide face masks to Canadians, and that might leave us in a shortage. So there's speculation that's going to be his announcement, but I'm not 100% sure. So after this webinar, you can tune into him. The essential lists of businesses were narrowed last week. There's huge penalties. The maximum penalty for operating a non-essential business is $10 million in imprisonment for up to 1 year. We have social distancing bylaws where you can get a fine for up to $5,000. And I've read that, I don't know if it's implemented yet, that it's being considered monitoring cell phones to see if people are gathering socially with more than 5 people. I don't know if that's going to be implemented, but there's a possibility. So now before I move on to the courts, what do all these laws mean for you as business owners? My thoughts are that more financial relief is likely to be ordered. And then there may be more laws implemented to assist businesses. I really do hope. But it's also going to create uncertainty. And when people are uncertain, unless it's an essential good or service, they're reluctant to spend money. So being a litigator, a trial lawyer, it wouldn't be fair for me not to explain to you what the court's doing about this. So small claims court, where your lawsuit is less than $35,000, it's closed, completely closed in Ontario. And so Superior Court, which is the next level up, actually has a jurisdiction over small claims court, and they're still in session. But Superior Court will only deal with emergency matters and settlement meetings with judges called a pretrial if it was previously canceled and both parties kind of agree that they're trying to settle the matter. Property issues may be considered urgent. We successfully argued one almost 2 weeks ago, and I'll discuss that later. And if both sides agree to a court order, a judge may also sign it. There's a suspension of limitation period. So what that means is if your 2-year period to sue, that's typical with a breach of contract, someone owes you money and you want to sue that person for the money. If that's coming up and you're about to run out of time, the limitation period has been suspended, so your time hasn't actually run out until further notice. So that's one huge change that has been made. Us as lawyers are expected to continue to abide by timelines. When courts eventually really reopen, and if we don't abide by timelines we've agreed on, it won't really look good for us or our clients. So what can you do to move your lawsuit forward? If you're in a financial dispute with someone, what can you do? There's quite a bit you can do. You can file your lawsuit or your defense online. You can schedule your cross-examinations or mediation virtually. You can exchange your evidence by email. You can work on your settlement. You can try and just settle the matter with the other side. You can prepare your testimony for trial if your trial is coming up. And just get as prepared as possible so you're ready to proceed when the court reopens. So I'll turn this over to Jordan to discuss employment matters.
Thank you, Tanya. I don't seem to have access to
Okay.
Oh, thank you. All right, so the first question that we have regarding employment matters comes from Peter Neal of Neal Brothers. So thank you, Peter, for the question. And it is, if we aren't forcing our staff to work and they contract COVID-19 while on the job, what liability do we face? Now, for the most part, workplace illnesses are generally governed by the Workplace Safety and Insurance Act, the WSIA. So as long as you comply with the WSIA, you shouldn't be held civilly liable for your employee contracting COVID. Your employee's course of action would be to apply to WSIB, the Workplace Safety and Insurance Board, for workers' compensation. So as an employer, your only obligation in that case would be to report the employee's illness to the WSIB within 3 days of your becoming aware of the employee's illness. Workers' compensation is determined on a case-by-case basis, and it's pretty safe to assume that there's going to be pretty fair deal of difficulty in actually determining whether COVID was contracted in the workplace or somewhere else that the employee could have contracted it, whether on public transportation on the way to work, interactions in their personal life, or even in the grocery store. It's going to be very hard to narrow it down. There are some businesses and industries in general that are not covered by WSIB, such as banks, trust companies, and insurance companies, private healthcare practices like doctors or chiropractors, travel agencies, barbers and hair salons, trade unions, and legal services such as our own. So employees of those businesses, they actually can bring lawsuits for lost wages, expenses that they incur as a result of their sickness, and damages for pain and suffering. Now that being said, as an employer, you do have the comfort of knowing that it will be very difficult for them to prove that COVID was contracted in the workplace. So the best thing that you can do to prevent such a claim being brought against you is to make sure that you ensure your workplace is as safe as possible. And that brings us to the next slide, actually. So the next question is, what are some best practice policies for dealing with COVID-19 in the workplace? Now, under the Occupational Health and Safety Act, all employers owe a general duty to each of their employees to provide a safe workplace. So in the current climate, really all businesses should have some specific safety measures that relate to COVID-19 in place. And it's very important that these policies are documented, and you should have them signed and acknowledged by an employee. I realize sometimes employees can take a while to get documents back to you signed, so it might be a good idea to include a clause that states, if not signed and returned by a certain date, this is deemed to have been acknowledged that these policies are in place. Also, again, given the current climate, you probably don't want to be sending a lot of paperwork back and forth. So a lot of these policies will probably be exchanged via email. So one thing an employer can do is include the requirement of a read certificate in the email, so that once the employee has received and opened the email, the employer gets an acknowledgement that it's been opened. So if there's ever any dispute as to whether the employee received the policy, you can show the read certificate that shows that, yes, they did receive it. So now some sample policies that you might want to include in a safety measure policy would be enforcing social distance in the workplace. If normally people are working side by side, right up close with each other, you'll probably have to make some physical changes to the workplace. You might have to do that by, at least at the very minimum, making sure that people's desks or workspaces are not any closer than 2 meters away from each other. Sorry, I think we're one slide ahead. If you could go back a couple, Tanya. We're going the wrong way. Yeah, perfect. All right, sorry. Oh, no, you're one ahead now. Yep, this is the right one. Okay. Another good policy is to make sure you restrict the visitors and clients from attending the workplace. I know that, I think right on March 15th or 16th, we sent out communications to all of our clients to let them know that unless there is an absolute emergency that explicitly required that we meet face-to-face, we would prefer that all of our communications be done via video conference or telephone. The court has actually used a lot of restrictions that have allowed us to do this more often, or some things that used to be required to be done in person, such as commissioning affidavits, the court now allows us to do them virtually over video conferencing. Again, another good thing that employees can do is accommodate remote work arrangements. I'm sure many of the participants today have already begun doing that. We've done that ourselves. I'm working from home right now, and I think at least half of our staff has been working remotely. And finally, it's good to promote proper hygiene practices in the office and provide supplies such as hand sanitizer and disinfectant wipes. Also, it'd be a good idea to make sure you have things posted within the workplace that might show proper hand washing techniques and can alert the employees as to where they can find supplies like disinfectant wipes, hand sanitizer, etc. And another real important point is if it's possible, you should get some photo or video evidence of the conditions in your workplace. I know we'd all like to assume that employees will, for the most part, be loyal and honest, but just, in the event that somewhere down the road, an employee does become ill and tries to say that, you didn't take proper safety precautions and they got sick at work and it was the employer's fault, it'd be very helpful if you can provide photo or video evidence that shows all the steps that you did take and, kind of mitigates the liability that you could face. All right. All right. So the next question is, I want to get advice on how temporary layoffs work since my contract does not allow for temporary layoffs. What is pay in lieu of notice? And can I be sued for constructive dismissal if I lay off an employee for more than 13 weeks? Now, I realize that many of the participants here today won't necessarily have a legal background, and so they might not be familiar with terms like constructive dismissal. So I'll start off with a brief explanation of that. So generally, when an employer terminates someone's employment, they have to give that employee notice of their dismissal. And in some cases, depending on the size of the company and certain other factors, they might owe them severance as well. What happens more in general practice is that instead of telling an employee or giving them notice that you're going to be terminated in 10 weeks, they'll just give them 10 weeks of pay in lieu of that notice. Because a lot of the time, if you let an employee know you're going to let them go in 10 weeks, they won't, be the most productive or give you the best level of work. So those people are generally entitled to notice and or severance, and whereas people who quit or resign, they're not entitled to anything. However, courts have come up with a legal creation called constructive dismissal that is for when an employee hasn't explicitly said that you're fired or you're being let go, but the court treats it as if they had and will still entitle the employee to notice or severance. It comes up in a couple common ways. One is where the employer or other employees have created a work environment that is almost poisonous to the employee, and it's become a real toxic work environment, and the employee feels that it's unbearable for them to continue there and they have no choice but to resign. In those cases, if the court finds that the employee's decision was reasonable, they'll say they were constructively dismissed and entitled to notice. Another more common one is if the employer unilaterally changes some of the terms of the employee's employment in a way that is beyond what an employee could reasonably expect. So a good example would be if an employee reasonably expects to get 40 hours of work and to be paid for those hours every week, and then one day the employer says, you know what, we only need you for 25 hours a week going forward. That's something that the courts would consider constructive dismissal. And so that sort of takes us to temporary layoffs, whereas generally an employee can reasonably expect that they'll have work every week. If their employer tells them one day, we don't need you for the next 10 weeks, come back then, that can be seen as a constructive dismissal. Now, the Employment Standards Act, which is the legislation in Ontario that governs employment matters, it does give employers, technically, it gives them the right to lay off employees for a maximum of 13 weeks in any 20-week period. However, the courts will still consider that a constructive dismissal unless a few things are present. One of them is if it's actually set out in the employment contract in writing that the employer has the right to make these layoffs. And of course, the employee has reviewed the contract and signed off on it. Or another option, if it's not in your contract, is to get the employee to agree in writing to the layoff before the layoff actually starts. So in that case, the best practice is really to communicate with your employees, let them know what your situation is and why you feel the need for the layoffs. If they kind of understand where you're coming from, they might be more agreeable to that. And then the third option when temporary layoff won't be considered constructive dismissal is if it's a business where temporary layoffs are common and expected. So think seasonal jobs like some landscaping, summer camp, golf course jobs, working at a ski hill. In those businesses, seasonal layoffs are just inherently part of the job. So if your employment contract does allow for temporary layoffs, they cannot exceed 13 weeks in a 20-week period. However, this limit can be extended to 35 weeks in a 52-week period if certain other conditions are met, such as if you continue to pay a substantial amount of the employee's salary, if their benefits are continued under the employer's plan, or if the employee is recalled within a time frame set out in an agreement with the employer. So that goes back to what I mentioned earlier. If you can get your employees to agree to a temporary layoff, you'll want to include what the expected duration or term of the layoff is going to be. So if you put it in that you're going to be temporarily laid off and we expect to recall you back to work within 20 weeks, as long as you do recall them within those 20 weeks, it won't be considered a constructive dismissal. And I should mention that most of this, at least right now, is only really applicable to owners of essential businesses that are still operating, because owners of non-essential businesses have actually been ordered by the government to shut down. So it's very unlikely that owners of non-essential businesses will be liable for constructive dismissal, because they have a good defense known as frustration of contract, which basically means that it would be impossible or illegal for you to carry out the original terms of your contract. And in this case, it's very unlikely that a judge would say that you've constructively dismissed your employees by not having them continue to work when the government has actually ordered you to shut down. Okay, the next question is, suppose you find out an employee has lied about being exposed to COVID-19 to get out of work. What can you do? This situation has actually occurred in Ontario already. In Hamilton, there was a McDonald's worker who actually forged a doctor's note saying that she'd contracted COVID-19. That resulted in the business having to shut down for at least a week, I believe it was. They had to pay for professional cleaners to come in and disinfect the entire restaurant. They had to give notice to customers that an employee had contracted the virus, and it created quite a stir and quite a bit of fear, I would imagine, people thinking that they may have been exposed. In that case, considering the severity of the lie, once it was discovered that she forged the doctor's note, the employee was actually arrested and charged. So the question here is this just a criminal matter, or can you actually fire an employee if they take such actions? So the short answer is that you actually can fire them, or if you would rather take less severe disciplinary actions, you may. Decisions in Ontario and elsewhere in Canada have held that the lack of trust that's created when an employee intentionally lies to you about being sick just to get out of work, that will be considered just cause for dismissing the employee, in which case you wouldn't have to provide any notice or severance pay. However, it may be fairly difficult to prove that they are lying about being sick. At this point in time in Ontario, you are still technically allowed to ask employees for a sick note, but I know in other provinces they've been drafting legislation forbidding employers from asking for sick notes, and it's possible that that might be the case here as well. We may see when Premier Ford gives his speech at 1 p.m. In a lot of the cases that deal with this issue, there have been smoking guns. I'll just mention one, Ineos Nova Limited, which is listed below here. In that case, an employee called up his supervisor and left a voicemail stating that he would not be able to attend work for the rest of the week because he'd come down with something. However, he somehow managed to forget to hang up the call, and the voicemail kept recording, and it caught a conversation he had with his next door neighbor about how he was going to do her drywall and a bunch of renovations at her house while he was off for the rest of the week. And it even caught him going on to brag about how he knew how not to get caught calling in sick, and that the secret was to only take a couple of days off at a time, because if you take a week or more, that's when they start to ask questions. Another one dealt with an employee who was caught. He called in sick, and his Instagram later showed that he was in Vegas at a bachelor party. So that's another idea. If you are a little suspicious that your employee might be lying about being sick with COVID-19, it isn't a bad idea to check their social media and see if they've been carrying on in a way that's not really consistent with somebody who's been diagnosed. So another question is, how can I protect my business going forward? Well, as I mentioned earlier, the best way to be allowed to temporarily lay off employees without being liable for constructive dismissal would be to make sure that it's set out in your employment contract. So we have a sample clause here. I won't go through the whole clause, but I would just draw your attention to the fact that in the first sentence it says the employer reserves the right to temporarily lay off employees in accordance with the Employment Standards Act. So it's very important that any clause you put in still provides for the minimum protections that the ESA allows for. You can't put it in your contract that you're allowed to lay them off indefinitely. And if you do put something in your contract that goes beyond what the Employment Standards Act allows you to, the clause will be held to be unenforceable. Okay, another question which comes from Dr. Phil Van Horn, who we thank for the question. This question is actually from an employee's perspective. And it says, if my employer cannot pay me on the agreed due date due to COVID-19, i.e. for services provided prior to March 15th and due on April 10th, and as a result, I received payment from the Canada Emergency Response Benefit, the CERB, can I still collect my full outstanding payment from my employer at a later date? Excuse me. Sorry. So I suppose I should first just give a brief explanation of what the CERB is. It's a benefit that the federal government is providing. It's intended to provide support to workers who have stopped working as a result of COVID-19 and who have not quit their jobs. In order to be eligible, you must have earned at least $5,000 in 2019 or in the 12 months prior to your making the application. You must expect to have received no income from employment or self-employment for at least a consecutive 14 days in the next 4-week block. This benefit is paid in 4-week blocks in the amount of $2,000 for a maximum of 16 weeks. It's available from March 15th, 2020, retroactively, to October 3rd, 2020. And in order to apply, you must have sent in your application by December 2nd, 2020 of this year. So in short, to answer the question, can you still collect your full outstanding payment, even though you've also received benefits under the CERB? Yes, you can, because it's intended to support people who were not able to work after March 15th. It does not cancel out your right to collect wages that you earned prior to March 15th for work that you actually completed. And the final question is, what are dependent contractors and what obligations do employers have to them in COVID-19? So historically, only employees were entitled to notice and severance when their employment is terminated. Independent contractors aren't entitled to any of those things. But there is an intermediate category in between, known as dependent contractors, and our courts have really started recognizing dependent contractors increasingly in recent years. So the two hallmarks that are really how you test whether somebody is a dependent contractor or not deal with the degree of exclusivity or non-exclusivity, which means if you're the only company that they have a contract with, or one of only maybe 2 or 3, and you give them most of their business, then they may be a dependent contractor. And the other indicia that will be examined is the amount of economic dependence that the contractor has on your business. So there was actually a case that came out from the Ontario Court of Appeal last year that kind of made this test a little stricter in favor of employers. In that case, it was a lawyer who 30% of her billings came from the Ontario Legal Aid Society. And when the legal aid terminated her contract, she sued and claimed that she was a dependent contractor. Now, the degree of exclusivity test she pretty clearly wouldn't make because she had all kinds of other clients, but she was arguing that she was economically dependent on this contract. Most people would think if 30% of your total income totally disappeared tomorrow, you'd say, yes, I depended on that economically. However, the Court of Appeal ruled that in order to meet the economic dependence test, that contract has to make up at least bare minimum 50% of your total business. So, sorry? Okay. So what this means for business owners is that if you are forced to downsize and...
I'm trying to get this done. Okay.
I'm gonna do it in there. Someone's got their mic on.
Okay, can you send it to me? You're blocking. Send it to me now. Thank you. Because I'm trying to do the application. I don't know how to do it. Thank you.
Jordan, I muted everyone. Can you hear me? Oh, I muted you accidentally. Sorry, 1 second. Okay, you're unmuted. Everyone else is muted.
Okay, sounds good. So yeah, I was just making one final point, and that was what the whole existence of dependent contractors means for our employers is that if you are forced to downsize as a result of COVID-19 and you're thinking of letting people go, don't just think that if someone's a contractor, you won't be liable for notice or severance. You should make sure that you don't account for more than 50% of their business, and you're not the only business that they have contracts with, because they could be found to be a dependent contractor and you could be liable. So pending any further questions that might be answered at the end, I think that does it for the employment section.
Thank you very much, Jordan. So I'm going to continue on with property matters. And so earlier, about 30% of you were concerned about employees, and the other 30% were concerned about property and lease issues. And so I will try to address as many of those concerns as possible. So I'm going into a few issues, just straight into it, and then I explain the law as I go through the issues. So first is residential tenancies. And Celia in the red font asks a question: what do you do if your tenant leaves without paying rent? How do you avoid this in the future? And what you can do, there's not much you can do with a residential tenant that decides to leave without paying rent. As many of you are probably aware, is that residential evictions are not permitted during the COVID-19 pandemic. The courts have actually confirmed the same, along with Doug Ford. But people have to, what needs to be understood is you can actually start your application to terminate your tenant if they did not pay rent. You can you have to call the board to find out the manner in which they want to receive your application. I don't know if they will actually accept your application, and a hearing may be scheduled by video conference. But when it comes down to the order to actually evict the tenant, you get that, but you actually have to give it to the enforcement office, which is a sheriff, which is controlled by the government of Ontario. And in that situation, the government of Ontario will not evict a tenant, but you can get the ball rolling in the meantime. So when the tribunal is open again and everything's gone back to normal, you'll be ahead in line. There is a continuing obligation to pay rent. Doug Ford or the courts weren't saying just don't pay rent. I think it's you're in a situation where you're deciding between paying rent and buying food, you really should purchase food. What landlords need to be aware of, that there's a movement which is quite popular in Hamilton right now called Keep Your Rent. And it's really where tenants are collectively not paying rent, so the landlord and tenant board will be overwhelmed with applications and then they can't possibly process them. So if you are in that situation, all I can say is there's very little you can do right now. But learning from that, what you would probably want to consider is collecting the maximum amount deposit possible from a tenant. And you can collect 1 month's rent or the amount of rent for a rent-free period, which is less. So if you let your tenant live there for 2 weeks for free without paying, the maximum deposit you're allowed to get is what that rent would have been. If your tenant actually has left without paying rent, you can sue the tenant. You can sue in small claims court because the landlord and tenant board is really for tenants. And so when the person leaves, they're no longer a tenant. But keep in mind, what the court will do for you is they will order that you've won, and it's up to you to collect your money. And so if this person cannot afford to pay rent, it might be a challenge collecting your money in the future. So what happens if you sold a property and you're trying to close and you find that there are issues when you're trying to close. What can you do? That's what happened with one of our clients in our firm. And we thought it was an emergency. This person was sued, did not know about the lawsuit, got a judgment against her, and it was registered on title to the property. So when she decided to close, she would have to pay out the judgment to that person when she didn't even know about the lawsuit to begin with. And so what we had to do is ask the court for permission to even listen to us. And the court agreed that it was an emergency. So then the day after, we argued before another judge on the phone to explain, the remedy we were looking for, which is to have the money for the judgment paid into our trust account, and then they can deal with that dispute later on, but to not interfere with the closing. And the court agreed with us. So another situation is you're a commercial landlord or tenant and rent has not been paid. On March 17th, 2020, the court orders a suspension of due dates. Can you change the locks on your tenant, or do you risk being locked out? I haven't seen any case law to deal with this with COVID-19, but I suspect that the limitation period on suspensions will not apply in this situation. Suspending limitation periods, like I explained earlier, is that you're running out of time and now there's an extension of time. With a commercial landlord, unless you actually have something in your lease that says when your commercial landlord can lock you out, it's by default with the Commercial Tenancies Act 15 days. So 15 days has passed and rent has not been paid, the landlord can lock you out because they don't actually have to go through the government and the sheriff and the enforcement office to lock you out. They can just change the locks. So I recommend if a commercial tenant has difficulty paying, that the commercial tenants try to come up with a solution with the landlord, because the landlord will then have to find someone else to take a tenant's place, and that might be difficult with the situation that's going on. And but if the landlord decides to change the locks on a tenant, the court has already dealt with that with the COVID-19 case, and they have deemed that to be an emergency. So they will most likely deal with that type of situation. So now I'm going to get into contract matters. And one thing, if you're a commercial tenant, what you may want to consider in the future is ensuring that your lease deals with pandemics or deals with difficult situations where you may experience difficulty with paying rent. And so one question I was asked was, what can you do if your commercial landlord or supplier increases prices to you to offset lower rent? Now, leases can't actually be changed unilaterally unless it's in the lease. And personally, that's a huge mistake I see when it comes to business people, because they're very, very busy. And so sometimes there's a tendency just to sign on the dotted line without reviewing the document. And then later on, there's not much we as lawyers can do to amend it because it's already been signed. So make sure your lease does not have any provisions where it could be unilaterally changed, the rent. But if it does, now would be a good time to try and renegotiate that. And my recommendation with leases, sometimes they expire, is just to have an automatic renewal because it's hard to keep track of when it expires, and perhaps increments of rent increase contained in that renewal. Now, supplier increases have been outlawed here, but it's only really with necessary goods like hand sanitizers. And that maximum penalty is $10 million in a year in jail. But usually, suppliers should supply pursuant to the terms in the contract, but the reality is sometimes they may not. There might be such a demand for their item that they might say, yes, I know that I agree to supply this to you, but I change my mind and I'm going to charge more because someone else is willing to pay more. And in that case, the court expects that you will minimize your damages and just perhaps buy it from that person or supplier or somewhere else. And then later on, you can deal with suing them for the difference in price. But it's really, a supplier shouldn't do that, but may. And so another questions that I've been asked are, what will the economic impact on Canadian companies be for ongoing projects in other countries? And from Shed Mystery, thank you. And what to do if an individual is no longer willing or able to pay pursuant to their contract, their obligations. And so I'll discuss with you briefly two major contract kind of terms. One is called frustration of contract, and that's what it really is. It's your contract's frustrated. You can't complete it. So Jordan spoke about it a little bit earlier. And that's when it's impossible to complete your contract and you don't even have anything that speaks to this in your agreement. And so you want to say, it's impossible for me, don't sue me, or if you sue me, you're going to lose because I just can't complete my part. And that's hard to prove that it's impossible. The courts created this type of law because people sometimes just forget to put that in there. So if you don't have frustration of, like, if it's not frustrated, you do, because if you don't have, like, if it's not impossible, it's just difficult to complete the contract due to COVID-19. You might have, there's a concert that someone's supposed to perform at and they can't because the stadium is shut down. There's another clause that actually is embedded in your contract called a force majeure clause, which means superior force. And it's when you actually write into your contract when you can get out of it or when it can't be terminated. And the example that I've provided, I've amended it a bit. I found it from a case. It deals with commercial leases. And so this is a situation where somebody may not be able to pay their rent because of the pandemic. They're not operating, they're a non-essential business. And so they've already included something along those lines in the contract. So you can see I underlined a pandemic because I added that, but it actually defines, okay, when does a superior force happen? I'm not going to go through it all, but it's a bunch, it's a list of factors really beyond anyone's control. And then it says a consequence. So looking at A, if operations are interrupted or suspended and cannot be commenced as a result of this, this lease does not terminate, meaning you can't change the locks on me until the pandemic is over for at least 30 days after. That's what it really means. And so this is something to consider if you don't have this in a contract, if you don't have this in a lease, if it's an issue now, but if it's not an issue, it would, if you have the time, it'd be great for you to include it in a contract, because if we have an event that happens a few years from now, you'll be better prepared. So I'm going to stop it now, the presentation now, to see if there are any questions. If there aren't any, I would be, I can answer them later on. If there are any, I'd be happy to answer them now. I'm trying to pull up the questions, but there. Okay, I don't see any questions. Jordan, do you?
Nope, not at the moment.
Okay, so I'll stop this here. I just want to thank everybody for their time. If you have any other questions in the future, you can email them to Jordan or I, and we can answer them for you. Thanks again, everyone.
Thank you.